Hello, everyone. Welcome. Today is April 22nd. Happy Earth Day. And we are here today to present to you on the U visa. So I want to thank you all for joining us for this training. This training is geared towards volunteer attorneys or accredited representatives who are going to represent folks in applying for U non-immigrant status. So without further ado, we're going to go ahead and introduce ourselves. My name is Trisha Teofilo Olave. I'm a senior legal supervisor here at the National Immigrant Justice Center, and I supervise our VAWA and U visa pro bono projects. And now my colleague Liz.
Hi everyone, my name is Liz Sanchez. I'm the coordinator for our VAWA and U visa pro bono project. Pass it on to Marissa.
Hi everyone, my name is Marissa Labella and I am our project's pro bono paralegal.
So today the three of us are going to be talking to you about how to prepare a U visa application. Everybody is muted, but you are welcome to type in any questions you have in the chat and we will respond to them throughout the presentation. We're also going to try to leave some room for questions at the end. So without further ado, I'm going to go ahead and get started. Okay, so can everybody see this PowerPoint? Yes? Okay, great. So we work at the National Immigrant Justice Center, and just to give you a little bit of a background on NIJC, we have a really unique approach to the work that we do. We do a combination of direct legal services with federal litigation, outreach, and advocacy work. So we are on the ground reaching out to clients through outreach. We go to a lot of social service agencies, domestic violence shelters, hospitals, clinics, schools, anywhere that people request an outreach from NIJC. And then we do consultations with clients to determine if they're eligible for any immigration relief. And so once somebody comes through to see us in our consultation appointments and we determine that they're eligible, we help them prepare to apply for a U visa in this case. We have our advocacy team and policy folks. We have an office in DC. We also have people who are working on policy at the state level and the local level. And then we have a federal litigation team that works on impact litigation. Today, we're going to talk about the various NIJC pro bono projects. We're going to talk about U non-immigrant visas. And then Marissa is going to talk to you about specifics with working with survivors of domestic violence. Then Liz is going to talk to you about the nuts and bolts of preparing a U visa case. And at the end, we're going to give you some referrals and talk about sort of what's next. So NIJC has a number of pro bono projects, and if you are a first-time volunteer with NIJC, you are welcome to reach out to us if you have an interest in working on any of these pro bono projects. We have a project that represents folks who are seeking asylum and fleeing persecution in their home countries. We have our detention project that represents adults who are detained by ICE. Our litigation project that works on federal impact litigation. We have pro bono clinics for naturalization and DACA and post-asylee refugee benefits. We also have a project that works with children who are applying for special immigrant juvenile status, and we have our VAWA and U visa pro bono project. So how do NIJC's pro bono projects work? Well, as I mentioned, the clients come to us usually through our intake system. We do a thorough assessment to determine if they're eligible for any relief. And once we've made that determination for what kind of relief they're eligible for, we help them gather the necessary documents to prepare and file that application with USCIS. Once we screen their case and accept it for filing, then they sign a retainer. So in this case, they would sign a pro bono retainer with us. NIJC remains of counsel, but we transfer the case to a pro bono attorney like yourself to prepare and file everything. Because we remain of counsel throughout the life of the case, we ask that you keep us informed of all filings and correspondence with the government and with the client and anything else that might come up. This pro bono representation includes technical support from us. We provide document review. We even provide malpractice insurance throughout the life of the pro bono case.
Hi,
So,
Tricia. Sorry
yes.
to interrupt, but it looks like the slides aren't going through.
Oh, thank you for letting me know. Yeah. Okay, 1 second here. Okay, now what do you see?
There you go. That's the
Yeah.
slideshow.
Roles and responsibilities.
Okay, great. So sorry about that. That's the screen that I thought you all were seeing. Now I think we're caught up. So the roles and responsibilities of each party in this process. NIJC provides the outreach, we do the consultations with the clients, and we prepare a case referral packet for the pro bono attorney. We also provide the training, and as I mentioned, throughout the life of the case, we provide technical assistance, review of drafts and filings. We also will talk to you about case strategy if something comes up out of the ordinary in the case. We'll keep you up to date on policy updates, continue to provide malpractice insurance, and we remain of counsel in these cases. The pro bono attorney, your responsibilities include doing a conflicts check. So when you take on a case, we ask that you conduct a conflicts check to make sure that there are no conflicts in the case. We ask that you reach out to the client pretty immediately after taking on the case to communicate with that person and let them know that you're going to be representing them in their immigration matter. And then we ask that you meet with them either virtually or in person, depending on how things are going and how comfortable each of you feels, but to try to prepare the case in about 8 to 12 weeks. Okay, so within the next few months, we will let you know if there is a deadline on the case that requires it to be filed by a certain time. You will know that when you take on a case. We ask that you provide for any translators or interpreters. So this would generally include translating of some documents, such as the client's birth certificate and or marriage certificate, and then interpretation for any client meetings that are necessary. So if you yourself don't speak the client's language, but there is somebody at your firm that speaks the language, then maybe this is a great opportunity to utilize support staff who would otherwise not have an opportunity to take on this type of volunteer role. We ask that you keep us informed of any things that arise in the case, you know, a change in the client's personal life, if they get married or divorced or are arrested. We also ask that you let us know whenever you file a case and send us a copy of that filing, and anytime you receive any correspondence from USCIS regarding the case. Okay, are you seeing our dynamic webpage with pro bono resources?
Yes.
Okay, so we have this great resource that's available to all of you on our website. We provide sample briefs, documents, FAQs, how-tos. We have manuals. We have a manual dedicated to the U-Visa pro bono project that includes appendices with samples for anything that you could possibly need for your case. Okay, so I'm going to jump right into what the U-Visa is and how to prepare a U-Visa case. Liz, do we have any questions so far?
No questions yet.
No? Okay, so can you go ahead and put that first poll out?
Okay, so the first poll question, have you ever prepared a U-Visa case? Yes, recently. Yes, a long time ago. Not yet, but interested. No, I have not, and I don't think I will anytime soon. Or I'm not an attorney or DOJ rep, and I can't file immigration forms. Okay, I'm going to close the poll. And I'm going to share the results, Tricia. So it looks like Most folks have not yet prepared a U visa case, but they are interested. And there's a few who have recently or a long time ago.
Okay, great. Well, thank you for letting us know. That gives us an idea of where you're at in this process and what we should focus on. So can you shoot that next poll right away too?
Okay, so for those that have filed a U visa case, what was the most difficult part of the process for you? So would that be working with the client, obtaining the certification from law enforcement, preparing and filing the application, waiting for adjudication, and maintaining client contact throughout the life of the case? So you can choose more than one. Just a few more seconds. Okay, I'm going to close the poll now. And some of the results are that most people find obtaining the certification from law enforcement would be the most difficult, and a few said preparing and filing the application itself.
Okay, well, that is very helpful for us to know. And for those of you that said obtaining the certification is the hardest part, you will be happy to know that most of our cases, the clients have the certification before we pass the case on to a pro bono attorney. So the hard work is done before it gets to you. For those of you that said filing the case is the hardest part, well, that's the nature of the pro bono project. So for better or worse, that's the part that gets transferred to the pro bono attorney. However, we are here to walk you through every step of that. So for those of you that aren't familiar with the U visa yet, we're going to talk about that right now. What is the U non-immigrant visa? Well, it's a visa that was created back in 2000 as part of the Victims of Trafficking and Violence Prevention Act. And it's a visa that was created to strengthen the relationship between immigrant communities and law enforcement. And it provides a mechanism for victims of certain crimes to remain in the United States in order to assist with the investigation or prosecution of that crime. Okay. So who are the actors involved? Well, generally speaking, the client and their family, if they have any, the law enforcement agency that they reported the crime to or who is investigating or prosecuting the crime, USCIS, because that's the agency where the client files their U visa application, and then the pro bono attorney and NIJC, because we're the ones that help them prepare this application. So why would somebody apply for a U visa? Well, generally speaking, if somebody is eligible for a U visa, they might want to apply because they can obtain non-immigrant visa, non-immigrant status, and employment authorization for up to 4 years with a potential for that to be renewed. But the U visa also provides a path to citizenship in that if you have a U visa and you are living in the United States for 3 years in valid U status, you can then apply for a green card. It also allows for you to petition for any derivative family members. So we're going to go through who qualifies as derivatives in a moment, but that relationship must exist at the time that the U visa application is filed. Now, there's some current litigation out there about marriages that take place after the principal files their U visa application. So that might be a possibility in the future, but currently that only exists in the Ninth Circuit, so not here in Illinois. Limitations. So the biggest limitation for U visa applicants is that there is an annual cap of only 10,000 U visas granted per year, which means that there's a huge backlog. And so because of that, USCIS has implemented a wait list. So what that means is when USCIS reviews your client's case, if everything appears approvable, except for the fact that there is no visa available at the moment, then they're going to place the client on the visa wait list and grant them deferred action. And with deferred action, the client is eligible to apply for a work permit. So although it's not as good as having the actual U visa, it is sort of an okay spot to be in while you're waiting for that U visa, in that you can get a work permit and renew that until you get your U visa. Okay, unfortunately, because of the large backlog, it's still taking many years for clients' cases to be reviewed and placed on that wait list. So if I am a victim of a qualifying crime, and we're going to get to what is a qualifying crime shortly, but if I'm a victim of a qualifying crime and I'm going to apply for a U visa, I can also include derivative family members, okay? The age of the principal applicant is what determines who qualifies as a derivative family member. So if I'm over 21 and I'm applying for a U visa, then I can include my spouse and any unmarried children under 21. If I happen to be under 21 and I'm the principal applicant for the U visa, then I can include my parents. If I happen to be married, I can include my spouse and any unmarried children under 21, and also siblings who are under age 18. Okay, so hypothetically, if I'm 20 years old, I can include my two parents. I could include a spouse, any unmarried under 21 children, and my siblings under age 18. So it could be quite a few family members who could benefit from the U visa. Now, if you think about that annual cap that I mentioned just one slide back, that annual cap of 10,000 U visas per year only applies to principal applicants. Okay, so in that case of the, for example, 8 people applying for U status, only the principal applicant would be counted against that annual cap. The rest would all get their U visas, but because they're not principal applicants, they don't count against the 10,000. And then it's important for us to mention that the standard of proof for U visa applications is any credible evidence. And the reason this is important, as I mentioned, Marissa's going to talk to you about working with survivors of domestic violence, but for many U visa applicants, especially domestic violence survivors, it is really challenging to obtain proof of the domestic violence. Now, if there was physical abuse, then it might be a little bit easier. But oftentimes, if somebody is fleeing a domestic violence situation, they don't have time to gather a lot of documentary evidence from their home. And so we often have to remind USCIS that the standard of proof is any credible evidence, and they should not be requesting more than that. So who qualifies to apply for a U visa? Well, you have to prove that you have been a victim of a qualifying crime, and there are both direct victims and indirect victims. So a direct victim is what we would most generally think of as a victim of a qualifying crime, the person who is directly and proximately harmed. This can include bystanders, and the most common example of a bystander in the U visa context would be a pregnant woman who miscarries as a result of witnessing a direct crime. So maybe that person wasn't the direct victim, but they were a bystander to the crime, and they suffered direct and proximate harm as a result of being a bystander of that crime. That's pretty rare. We don't see a lot of bystander cases, but it's important for you to know that that is possible. Indirect victims, on the other hand, are a bit more common. That comes into play if the direct victim is murdered or incompetent or incapacitated, then an indirect victim can apply for the U visa, and that could include the spouse, children under 21, and parents if the direct victim is under 21, and siblings, again, if that direct victim is under 21. So what we see most commonly here is child victims of sexual assault. If the child is a child at the time that the crime occurred, then due to their age, they can be considered incompetent or incapacitated, and the parent can qualify as an indirect victim. So in order to apply for a U visa, a principal applicant must prove that they have suffered substantial physical or mental harm as a result of the qualifying criminal activity, that they have been helpful, are being helpful, or are likely to be helpful in the investigation or prosecution of the criminal activity. And take note that it's one or the other. So you don't necessarily have to be helpful in both the investigation and the prosecution, but you have to prove helpfulness in one or the other. The immigrant must possess information regarding the criminal activity, and the activity had to violate US law or occur in the United States. All of this can be found at INA, the Immigration and Nationality Act, Section 101A15U, and in the Code of Federal Regulations at 8 CFR 214.14. So here's a list of qualifying criminal activity that makes someone eligible for a U visa. And as you will see, this includes attempts, conspiracy, or solicitation to commit any of the crimes listed. But it also can include any similar activity in violation of federal, state, or local law. Okay, and that's because criminal statutes aren't the same across all jurisdictions in the United States. So this is a list of qualifying criminal activity, but the way the statute is listed in one jurisdiction might be different than someplace else. So for example, here we see a lot of felonious assault cases, but depending on the crime listed on the police report that is investigated or prosecuted, we may have to make an argument that that crime is substantially similar to the crime of felonious assault. Okay. So we're going to go through each element of eligibility to talk about how somebody is eligible as for a U visa. But Liz, can you go ahead with poll number 3 first?
Okay, so in order to qualify for a U visa, does the criminal case have to end in prosecution of the perpetrator? So there is a right answer here. Okay, a few more seconds for everyone else to vote. And I will be closing the poll right now. Okay, so for those that did answer, most said no. The case does not have to end in prosecution of the perpetrator in order to qualify for the U visa, while a few did say they were unsure, but nobody said yes.
So that's correct. Yeah, it does not have to end in prosecution. You know, if it does, you probably have a stronger case, but it's absolutely not a requirement. Under the law, it really only has to be investigated or prosecuted. Okay, so sometimes there are cases where the client reported that they were the victim of a crime and helped with that detection and investigation, but then maybe the perpetrator fled, and so there was no prosecution. Okay, that's okay. The person can still apply for a U visa. Can you go ahead and do poll number 4?
All right, so which of the following crimes could lead to a U visa? So you can choose more than one: domestic violence, violation of an order of protection, burglary, armed robbery, and attempted murder.
So this one is a little tricky.
Okay, just a few more seconds and I will close the poll right now. Okay, so to share the results, 100% of people said domestic violence would be one of them. Also, attempted murder had a 78% response. Armed robbery goes in third. And then violation for an order of protection and burglary would also be 44% of folks chose that answer.
Okay, very good. So I can see a little bit of hesitation with, you know, violation of an order of protection and burglary, and that's good because those crimes are not as obviously eligible for a U visa. It's going to depend on the facts of the case. So domestic violence, you're all right. Yes, 100%. That is a qualifying criminal activity. And attempted murder, right? So it includes attempts, conspiracy, or solicitation to commit any of the crimes listed here, and murder is one of them. So both of those are very clearly U visa eligible. The violation of an order of protection, it's going to depend on if you can connect that to a qualifying crime. So most likely you would try to connect that to domestic violence, but you're going to have to show that the victim was a victim of domestic violence also, not just the violation of an order of protection. And armed robbery is oftentimes similar to felonious assault here in Illinois if you can show the use of a weapon. But again, you'll have to look at the statute, and you'll have to look at the narrative on the police report to make sure that it matches up. Burglary is the least likely to qualify as a criminal activity because the definition for burglary doesn't exactly fit any of these qualifying crimes. However, depending on the narrative in the police report and if there are aggravating factors, then maybe it could qualify as a felonious assault. But burglary in and of itself would not qualify because there might not have been a person there, right? So, for example, like a burglary or home invasion, there's not necessarily a victim present at the time. So thank you for participating in that. On to the elements. So substantial physical or mental abuse. How do you prove this? Well, USCIS says that no single factor is a prerequisite, which is important, especially in domestic violence cases, because we know, and Marissa's going to talk to you about this, that working with survivors of domestic violence is challenging, and oftentimes there's not one incident that causes somebody to leave, right? Sometimes it's years of abuse that create a scenario where somebody decides to leave or call the police. And so maybe the time that they called the police wasn't quite as bad as maybe some of the other incidents that you're going to connect to in your U visa case. But USCIS will consider the nature of injury inflicted, the severity of the perpetrator's conduct, the severity of harm suffered, and the duration of infliction of harm. So if this is a domestic violence case where there has been years of abuse, you can include all of that information in your case, but you are going to also have to prove that they have been helpful in reporting, investigating, or prosecuting the criminal activity. Okay, so the definition here of physical or mental abuse is defined as injury or harm to the victim's physical person, or harm or impairment of the emotional or psychological soundness of the victim. And that's straight from the Code of Federal Regulations. Second, you have to prove cooperation with law enforcement. And as I mentioned, it's either the investigation or prosecution, or both, if you have that. The way that you have to prove this is with a certification form that is signed by law enforcement. Okay, that's Form I-918 Supplement B. And you have to have this form signed by law enforcement. If you don't have a signed certification, you cannot apply for a U visa. So we ask that you review the certification form very closely to make sure that there's no harmful language. For example, language that says that the victim was not helpful or that they refused to cooperate, things like that. Even if you have a signed certification, sure, you can go ahead and apply, but if it has harmful language on it, it's going to make it much harder for the client to get an approval from USCIS. So we would prefer to try to get a positive certification before filing that case, okay? You have to show that you've been helpful in assisting law enforcement, and for those who are under age 16 or incompetent or incapacitated, it could be a parent, guardian, or next friend that provides that information. The responsibility to cooperate and provide helpfulness is an ongoing responsibility, so even after the U visa application is filed, the applicant should continue to cooperate if requested from law enforcement. The applicant must prove that they possess information, so the individual must have knowledge of the details of the qualifying criminal activity that would assist in the investigation or prosecution. And again, if the victim is under 16, then it can be a parent, guardian, or next friend. So here's a sample of the U visa certification form. It has to be completed and signed by the head of the certifying agency or someone who is designated by the head of the agency. It can be a law enforcement agency, it could be a prosecutor's office, or it could be a federal, state, or local judge. And the certification is only valid for 6 months, okay? So if you get a certification signed today, April 22nd, 2021, then on October 22nd, 2021, that certification is deemed expired. So you would need to have your U visa application filed by October 21st, and that means it has to be received at the USCIS Vermont Service Center by October 21st, okay? If it doesn't get there until October 22nd, they're likely to determine that the certification was expired and your client's not eligible for a U visa. They are very strict about the 6-month eligibility for the certification. This certification, as I mentioned, is 100% necessary for a U visa applicant, but it is not conclusive evidence of any of the eligibility requirements. So what I mean by that is just filing a U visa certification is not enough to get your client's U visa approved. This is necessary, but you still need to prove all of the elements of eligibility with other documentary evidence. And then finally, you need to show that your client is admissible. So for those of you that are familiar with immigration law, inadmissibility is really common. People can be inadmissible for any number of things. These are the inadmissibility grounds are found in the INA at section 212A. And the most common inadmissibility grounds that we come across are listed here. Many of our clients are inadmissible because they entered without inspection, or maybe they brought their children here with them illegally, which would be smuggling, or maybe they have prior immigration deportation orders or prior immigration violations. They might have a false claim to US citizenship or fraud or willful misrepresentation. So all of those things would make them inadmissible. Fortunately for U visa applicants, they can request a waiver of inadmissibility. And this waiver is on form I-192. It's the U non-immigrant visa waiver. And in order to be eligible for the waiver, the applicant must show that it is in the national or public interest for the waiver to be granted. So they don't have to show hardship to any qualifying relatives. They just have to show that it is in the national and public interest for that waiver to be granted, which is pretty vague. It is a discretionary waiver, but USCIS will consider a number of factors. So if you look at this list, it is a non-exhaustive list, but they will look at, for example, evidence of rehabilitation. So if your client is inadmissible for a criminal ground, if they can prove that they have rehabilitated and they're not continuing to commit those crimes, then maybe they can get their waiver granted. You would want to include any mitigating factors in favor of your client, the reasons that they wish to remain in the United States. You have to include an affidavit explaining the specific circumstances that create their inadmissibility and why it is in the national and public interest for the waiver to be granted. And then we usually include any information about loss of access to the criminal justice system or physical, medical, and mental health services, social services that they wouldn't have access to in their home country that are available to them here in the US. Now, the U visa form, the U visa application is on form I-918, and that form does not have a fee for USCIS. So if you are filing a U visa application, you do not have to pay a fee to USCIS. However, if you are filing a waiver of inadmissibility because your client is inadmissible, the form I-192 waiver does require a fee of $930 or a fee waiver request, okay? So Liz is going to get into fee waiver requests later, but most of our clients do qualify for fee waiver requests because all of our clients are at or below 200% of the federal population. Okay, so I want to mention here that the U visas do qualify under these confidentiality provisions that are found in Section 384 of IRA, the Illinois Immigration Reform and Immigrant Responsibility Act. So these confidentiality provisions prohibit all Department of Homeland Security and Department of Justice employees from providing information about a U visa to third parties, okay? And that's really important for a lot of our clients because they may be afraid to apply for a U visa for fear that the perpetrator is going to find out and retaliate against them, okay? So this is very important that they understand that that perpetrator is not going to find out that they applied for a U visa unless they tell them, okay? So we tell our clients not to notify the perpetrator, especially if it is, you know, a family member or a former partner, that they're applying for a U visa because it could hurt them in the end. Section 384 similarly prohibits Department of Homeland Security officers from making any decisions about removability based solely on information provided by an abuser. So for example, if the perpetrator of the crime that makes someone eligible for a U visa is an abusive spouse or partner, and that person sends USCIS information or tells them, calls them to report that this person is making it up just to get a U visa, USCIS is not allowed to make a decision about the client's removability based solely on that information. Okay, they would have to do an investigation and allow the client an opportunity to respond. Okay, so we have just a couple minutes before I'm going to turn things over to Marissa. So we'll go through one case example here. Ana is a Mexican citizen who entered the US without inspection in 2010 with her 1-year-old child. Okay, and then 2 years later, she married Juan, who is undocumented, and they later had 2 US citizen children. During their marriage, Juan did not let Ana leave the house without his permission. He controlled all the money and often threatened to have her deported. On one occasion, Juan repeatedly hit her and she called the police, but he fled before the police arrived. Ana filed a police report, but Juan was never arrested. Thereafter, she took their children to a domestic violence shelter and obtained a civil order protection. She is seeking a divorce. Juan continues to call her and threaten her. Do you think that Ana is eligible to apply for a U visa? Give you a second to read it over. So yes, Ana is eligible to apply for a U visa. She's been the victim of domestic violence, which is a qualifying crime. She has cooperated with the investigation of the crime, despite the fact that there was no prosecution and Juan was never arrested. She did report the crime and assisted in the investigation by talking to the police. She also obtained an order of protection. So that is additional evidence that goes to show that she has been helpful. So you would include copies of the police report, the order of protection. You could even include the copy of her divorce petition. Now, she may be inadmissible, right? She entered the country without inspection and she brought her child at the time. And that child, who was 1 year old in 2009, 1 year old in 2010, born in 2009, is still under 21 years old, so they could qualify as a derivative on this application. Okay, so you would want to file this U visa application before the child turns 21 so that they could be included as a derivative, but also if we get a certification, then we have to file it within the 6 months before the certification expires. Okay, so that's just one case example. We'll get into more at the end of the training. I'm going to go ahead and turn things over to Marissa. Marissa, let me make sure that we're not having any technical difficulties. I'm going to think that we're good. I'm going to go ahead and take it away.
Thanks, Trisha. So we recognize that for many of you, this might be your first time working with survivors of domestic violence. And so with that being said, we're going to go over some helpful tips and tricks to sort of guide you as you're working on a U visa case with a survivor of domestic violence. So many advocates use the power and control wheel to help survivors visualize forms of abuse that are not always physical or that you can't always see. Not only does this help our clients better understand how their abuser has exerted power and control over them throughout their relationship, but it helps us as advocates to build a stronger case by thinking more holistically about what domestic violence looks like. So if you could go to the next slide, Trisha. Thank you. The power and control wheel is one of my favorite tools to use when working with survivors. I usually have my clients study the wheel in our meetings and identify some of the forms of power and control that have been used against them. And this really helps people recognize, like I mentioned, forms of domestic violence or abuse that are not always physical. So a lot of times my clients will study the power and control wheel and say, you know, I never realized that not being allowed to leave the house was domestic violence, or I never realized that not being able to go to doctor's appointments or receive vital medication was abuse. So again, we encourage you to think of the wheel as a diagram of tactics that abusers use to keep their partners in an abusive relationship And again, try to incorporate this into your client meetings. Oftentimes, we see that our clients have been trapped in a cycle of abuse that includes 3 stages: tension, explosion, and the honeymoon phase. In the building tension phase, this includes small microaggressions. So maybe a brief incident of physical abuse, or it feels like you're walking on eggshells around your partner, or like anything you do might set off the abuser. And our clients usually live in this stage for a long time. Trisha, if you could please click the slide. Thank you. In the next stage, the explosion stage, this is one of the scariest moments for our clients because something big will happen, like an act of aggression or, you know, screaming, insults, things like that. And this is when the abuser seems to lose control over their actions. They're lashing out. The victim might not know what the abuser is going to do. A lot of times, the victims are in fear for their lives. And this might be the point where they call the police and make a police report. Often after the explosion phase, if the victim wants to stay in the relationship or go back, we see what is called a honeymoon phase, or a period of calm and reconciliation. In this phase, the abuser might try to apologize for their actions and ask for forgiveness. They might give the victim gifts. They might make a lot of promises, saying things like, I will file immigration papers for you. If you stay with me, we can work on things. I'll never hurt you again. So again, this is a helpful tool that we encourage you to use in your client meetings to sort of help your clients understand the full picture of the abuse that they have been suffering. I also want to caution against victim blaming, or the idea that the abuse is the victim's fault. A lot of times survivors blame themselves for staying in the relationship, but obviously they are not at fault for what they are experiencing. So yeah, avoid, you know, thinking or saying, you should have left when this happened. You should have known it was going to happen again. Although it is really difficult for advocates to see our clients go through these types of situations, and it may be first nature to ask why they didn't leave, it's important to get the best understanding of the client situation and support them in gaining independence in the way that works best for them. And ultimately, the client is going to be the one that knows their situation the best. In addition to the control that survivors are living under, many face cultural barriers in disclosing the abuse or getting help. Many of our clients are monolingual Spanish speakers. Many are isolated from family and friends and aren't allowed to leave their house unless they are supervised by the abuser, making it difficult to disclose the abuse. Even if they are allowed to visit family and friends, they may feel ashamed of disclosing the abuse. It may be something that is framed as not appropriate to talk about in public. So all of these barriers are important to keep in mind when trying to understand why the abuser or why the victim didn't leave, or why they didn't seek help sooner. Unfortunately, misusing immigration privilege is a very common form of control used by the abusers. Sometimes the abusers hold immigration status. They might be a permanent resident or a US citizen, and they might offer to file papers for their partner but then later use this as a form of control, promising to file an I-130 family petition for them, and then later, if they file it, threatening to withdraw it if the victim does not stay in the relationship with them. Knowing that their partner does not have immigration status, sometimes abusers will call immigration to have them take their partner away, and then threaten to take custody of the children if there are children in that relationship. Thankfully, the U visa provides survivors of domestic violence with a way to legalize their status independently from their abuser. So next, we're going to talk about how to actually prepare a U visa case. Pass it over to Liz.
So actually, thank you very much, Marissa. We are going to take a short break. We've got room for about a 10-minute break. So go ahead and relax, stretch, grab a bite to eat, get some coffee, whatever you need to do. We'll see you back here at noon Chicago time, 1 o'clock Eastern, and 10 o'clock Pacific for any of you on the West Coast. Okay, Liz, your turn. And just want to make sure, can everybody see a big green box that says preparing a U visa case?
Yes.
Yes.
Okay, take it away, Liz.
All right, on to the most favorite part of everyone. I know this is everyone's favorite, but this is actually a very detailed section, many slides, and so I'm not going to go over every single slide since they're just text heavy. This section is primarily used as a resource, we hope, for pro bono attorneys who are working on their U visa cases. So Trisha, you can go to the next slide. All right, so connecting with clients. From the beginning, it's important to create a safe space where your client can feel safe. So this might look different now that we're in a pandemic and we're working remotely. So on our website, we actually have some great resources on best practices for attorneys working remotely with clients. We will send all of these resources as a follow-up email after our training. And so during this first meeting with your client, it's a good idea to explain your relationship with NIJC. Although we do explain this when we sign our pro bono retainers, it is still important to reiterate this with your client because at this point, they've already received so much information and we just want to make sure that everyone is on the same page because they might have a lot of questions still. And it's always good to keep in mind that speaking simply on a one-to-one level instead of using complicated legal terms, it's a good way to speak to your client, to communicate the process. So if you also need an interpreter, remember to secure one before you meet with your client for the first time. This would be essential in building that safe space and preparing your case. Also, stressing confidentiality is extremely important. When trying to build rapport with your client, explaining that you will not be sharing any information with anyone else unless they grant you permission to do so with the release of information, such as to speak to a counselor or to anybody else. This would be very important. A lot of people can have anxiety actually about their abuser or anyone in their family finding out about the case. Therefore, stressing that this is a safe and confidential space and creating that space for them will be very beneficial. Additionally, setting up a good communication plan is crucial, especially for individuals that are living in shelters or maybe in unsafe situations at home. And so we usually ask our clients when we meet with them on a consultation what their preferred method of communication is. We always make sure to flag if someone's home address is not safe in our referral packets, but the client might move around or circumstances may change. So if the client is living with their abuser, for example, their phone could potentially be monitored and they might not be able to receive mail in fear that the abuser could see it. So it's good practice to ask things like, is it safe for me to leave a voicemail at this number? Do you have a preferred address or has it changed? Furthermore, explaining the process of the U visa is important in building that relationship of trust so that the client understands how long processing times are for U visa cases and to get a work permit especially. Understanding what are the different fees, if they will need a waiver of inadmissibility, and what documents they still need to gather to bring to you. And during our own screening process, we get the certification for you. As Trisha mentioned, we do that hard labor. We put together the referral packet with all the documents that the client has to support their case, but it's always a good idea to review everything closely individually before meeting with the client, and then when you meet with the client, also review it with them to see if there's other pieces of evidence that can be included or excluded to strengthen their case. And we have a sample list of documents for you in our manual appendices and numerous resources up on our website with all of this information. And lastly, something that might come up is that the client might ask you questions beyond the scope of the case. For example, they might ask about counseling, tax assistance, or other services. And so we don't expect you as their pro bono attorney to answer any questions beyond the scope of the case. And what you can do is just reach out to NIJC, to Trisha and I. We have many great referral options that we'd be happy to provide you and the client with. Okay, next. And so Trisha already touched on this, but it's important to make sure that you have the original U visa certification form. First and foremost, make sure that you have the original, make sure that you have all the pages, because if you don't, then obviously you can't file that U visa application. So it's good to make sure, whether the client has that original certification form to send it to you, or if we have it, we will let you know, and then we can send it directly to you. We recommend you also get to know your client's story. This is part of building that relationship of trust. Begin filling out the application forms as well in that initial meeting. Give the client a list of additional documents that they need to bring, and schedule your next meeting. In subsequent meetings, you can begin working on the affidavit. And so we recommend that you wait until you had a couple of meetings with your client before starting on the affidavit, so that you have time to build a relationship and a safe space. But this is all on a case-by-case basis. You should gauge your client's comfort level always. Make sure that you have an interpreter. You might have someone who potentially was a victim of felonious assault and the incident happened several years ago, let's say, and maybe they've moved on. Maybe they've already processed that trauma, they've gone to a counselor, or they have not, but either way, maybe they're ready to work on their affidavit in the first meeting. This is not the case for every single client. And so it's good to be aware that not everyone is going to be ready to share their story right away. And so the difficulty in telling one story is also compounded when having to use an interpreter. So do keep that in mind. And so some people might immediately open up to you and others might be reluctant, and that's okay at first. What we like to do in our referral packets are share our internal case notes with you. So this is part of our legal screening where advocates write the notes that they took while they were speaking to the client, so that you have a basic understanding essentially of who this person is, who their family members are, what they've gone through in relation to their case, so that you have kind of like a basic understanding and you don't go into the meeting like not knowing anything at all. So you should definitely confirm all of that information as well as take a look at it before your meeting. And so if working on a, if working on a domestic violence case, everything that we talked about before when looking at the power and control wheel is going to be super helpful when sitting down with your client to write their affidavit. And so we recommend you use that wheel as a tool to identify some of those forms of abuse that the client might not have thought about before. And when your client does open up to you about traumatic events in their life, and the details regarding the crime they suffered, you should actively listen, be non-judgmental, as much as possible. Try to be as empathetic as well and validate their decision to disclose all of those really difficult moments that they've gone through in their life, and now that they have to open up to someone and apply for this benefit. So what I like to do when I meet with clients is part of validating is thank you for having the courage to share that. I could also say your feelings are completely valid. I get why you might feel that way. And if someone is still living in an abusive situation, I might also help to ask, what they need right now, if there's anything that you can do to support them. Never ask questions that begin with why, or ask leading questions which leads the client to answer in the way that you want them to. This is super important. So it's appropriate in this case to ask open-ended questions, such as those that start with how or what. For example, how did you feel when they said that to you, right? How did it make you feel? So that you can write, the best affidavit possible for your client. We can move on to the next slide. And as for evidence, each principal and derivative applicant must have their own application packet. So this includes a cover letter, forms, identity documents, supporting documents, and affidavits. And again, what should an affidavit look like to start? It should be in the applicant's own words, because this is the chance that the client has to tell their story. And what this means is that the client can write their affidavit in their native language and then have a certified translation of it. However, we often find that the best affidavits are the ones where you as the attorney sit down with the client on one-on-one and draft something together. So that might mean you asking the client questions, and then the client's original signature will be on the affidavit, and the interpreter, if there was one used, also needs to sign to show that they provided an accurate and truthful interpretation, and then translation of that affidavit if necessary. And the affidavit should address some key things, such as the biographic information, substantial harm, knowledge and information of the crime, how they were helpful in the investigation or prosecution of the crime, as well as why the granting of the U visa and the waiver, if applicable, is in the national or public interest. And for principal and derivatives, identity documents are needed, but for principal applicants, the U visa eligibility supporting documents are required to prove that they've been, 1, a victim of a qualifying crime, 2, that they suffered substantial harm, and 3, that they cooperated with law enforcement. And additionally, if anyone needs a waiver of inadmissibility, obviously you need to include any supporting documents for that to demonstrate to the government that they merit this waiver and exercise of discretion. Okay. So before moving on, there's no questions, right, Trisha? I don't think there is.
No.
Okay. So for filing procedures, so these are the things that you'll need to file your application packets for both your principal and derivative applicant. It's good to follow these procedures because we know that the Vermont Service Center prefers a clear way of identifying who is a principal applicant and who is a derivative by having separate application packets. So we'll go into detail on the next slide. Okay. All right, so for principal U visa applicants, we basically outlined here all the forms that you will need, as well as the supporting documents. So you will need a cover letter, an index of documents, and the following forms. So that would be a G28, Form I-918, which is the U visa application, the original U visa certification form, the Form I-192, which is the waiver of inadmissibility if necessary, and an I-765 form, which is the work permit application, including 2 passport-style photos. You'll also need to include the correct fees for the waiver and the work permit application if it applies, or apply for a fee waiver request with supporting documentation, and this would be the Form I-765 912. Okay, so next we have the U visa derivative application. You will also need a cover letter for this, an index of documents with the following forms. Note that you should be including 2 G28s, just as we list here. So one would be for the petitioner, which is the principal applicant, and the other one would be for the beneficiary, which is the derivative. And so you'll also need an I-918 Supplement A. This is the derivatives U visa application, and a waiver of an inadmissibility if necessary, and an I-765 work permit application. So if the derivative is in the United States, you would include this work permit application along with the appropriate fees or the fee waiver request. And here we list supporting documents that you should include. For the derivative, note that you will need to prove that the qualifying relationship of the derivative is to the principal applicant. So that could be if the derivative is a child of the principal, birth certificate. If it's a spouse of the principal, then you'd include the marriage certificate. I'd also like to point out here that there are 2 work permit applications listed, one for category A20 and another for category C14. And so I will go into more detail regarding these work permits in our next slide. Thank you. And so in terms of employment authorization, so clients have a lot of questions about this because it's confusing. So I'll try to break it down, but please let us know if you have any questions. So essentially, USCIS will automatically issue an initial work permit with category A19 when they grant the U visa for the principal applicant. This work permit is valid for 4 years. Okay, so the term here is automatic, right? So you don't need to file anything separately in order to receive this once the principal's application is approved. For derivatives, however, they will not get an automatic work permit when their U visa is granted. So you will need to file the form I-765 when their I-918A gets approved in order for them to receive a permit valid for 4 years. However, this 4-year work permit will be in the category A20. As you can see, there are various categories for employment authorization, and we've included them here. Now, due to the cap of 10,000 U visas per fiscal year, USCIS will issue a waitlist notice and grant deferred action for applicants in the US, just as Tricia mentioned earlier. This allows people to be eligible for a work permit while they wait for a U visa to become available. Therefore, we recommend that when you're initially filing the U visa application, if you're including a fee waiver request, you should also include the form I-765 for both principal and derivatives in order for them to apply for a category C14 work permit, so that when their case gets to the wait list, right, this could be several years from now, USCIS will just send over the work permit once they're granted deferred action and placed on that wait list. However, if you initially did not file that C14 work permit application when you initially filed, that's okay. You can do so once the client is on the wait list. And so remember, right, that the wait list is really long and this can change at any time. So it's important to just set expectations about this with your client, and you might find yourself having to repeat this process because essentially the work authorization is one of the most important things for people. This is why they seek immigration relief. Therefore, you will get questions on this. So be prepared to just explain all of this maybe more than once. Okay, so here we have the filing fees. As we mentioned previously, the form I-918, which is the U visa application, and the derivative application do not have a fee. However, the waiver of inadmissibility and the work permit do have fees. And we recommend that when paying these fees, the client provide a money order payable to the U.S. Department of Homeland Security, or if the client would like to request a fee waiver, then you would need to include that form I-912 and supporting documents for that. And so we recommend that you look at the USCIS website often to make sure that you have the correct filing fee, because they're subject to change at any time. Okay, so fee waivers. To request one, you need to submit the I-912 in each application packet. And so USCIS will approve a fee waiver based on their discretion for any applicant that can provide proof of one or more of the following. So if they are receiving a means-tested benefit, if they have a household income of 150% or below the poverty guidelines, or if they can demonstrate financial hardship. And so this is where the client and you might need to get a little bit creative in trying to figure out what kind of documents can they provide if maybe they haven't been working at all, or if they haven't filed their taxes, right? And so we usually try to talk about this with the client in our initial consultation with them so that they're aware, but they might need to continue gathering documents as their case is referred to you as their pro bono attorney. And so as many documents as possible to prove that they qualify should be included because the Vermont Service Center is actually getting a little bit more difficult each and every day in approving these fee waivers. Okay, so for filing tips, here we include some things that you should keep in mind when you're filing. You should always include a certified English translation for any foreign document that you submit. We provide a certificate of translation template for you to reference in our manual. And for all USCIS forms, confirm that you are using the most recent version, because USCIS does update their forms pretty regularly. So some logistical tips that we like to include here too is that application packets should be 2-hole punched at the top and binded with metal prong fasteners or a binder clip. So do not use any spiral binding. Do not use tabs or other exhibit markers. Use page numbers instead. And so the reason for this is because when the Vermont Service Center receives the application packet at their center, they have to scan the whole application packet. And so usually if there's anything obstructing that, it's going to create problems. So we just recommend not to do any of that. So again, you'll need to prepare separate application packets for the principal and derivatives. And when you're ready to file the application, you will place all the application packets into one mailing envelope and then send via FedEx or any other trackable delivery service. And you will keep a digital copy of the final application packet that you send to USCIS so that you can forward it to NIJC for our records. Okay, next. And here we've included the address where you will mail the application, which is the Vermont Service Center. Okay, next. And here we have somewhat of a timeline, if we can go back to that. Yeah, so here's the timeline for a U visa. It can take about 4 to 8 weeks after you file that application to receive a receipt notice indicating that USCIS received the application. Once that's been received, you will then get a biometrics appointment notice for your clients. Applicants should attend their biometrics appointment or their application will be considered abandoned. And to the appointment, they would just need to bring their original biometrics appointment notice and a government issued photo ID. You as our pro bono attorney do not need to attend these as they're super quick, standard. And actually right now, because of the pandemic, we have seen major delays in the issuance of biometrics appointments. So if there are any concerns regarding this, we do recommend you reach out to us. And for clients with derivatives outside of the US, NIJC can guide you through this whole process. Essentially, the client will receive a request for evidence with an FBI print card to send to the derivative who might be living abroad, and then they can get their fingerprints taken at a US embassy, and embassy officials will then process the prints and send them to the Vermont Service Center. And after the biometrics, oh, yes?
Sorry, Liz, I want to jump in. There's one question here that I wanted to address because it might require a little follow-up. But the question is the deferred action status approval discretionary? What if the applicant filed a C-14, I-765, and doesn't receive an approval? So, you know, what Liz is talking about here is if you get placed on the wait list, if your case is placed on the wait list, you're granted deferred action as long as you're living in the United States. So it's not exactly discretionary in that if you qualify for the U visa, you should be placed on the wait list and granted deferred action, but the waiver is discretionary. So they could not place you on the wait list if they decide that your waiver isn't approvable. So, and that's not a very clear answer, but if your client needs a waiver of inadmissibility, then yes, that is discretionary, okay? But then the second part of this question is, what if the applicant filed that C-14, I-765, and doesn't receive an approval? So you won't actually get a decision on that until your case is placed on the wait list, which right now is taking about 5 or 6 years. So, you know, you shouldn't expect anything on that pending I-765 until your client's case is placed on the U visa wait list. If your client's case is placed on the U visa wait list and you still haven't gotten that C-14 approval, then you should file an inquiry with USCIS. Sorry.
Yes, thank you. No, thank you. Thank you, Tricia. So after the biometrics appointment, there will be a long wait time. Just as Tricia mentioned, it's going to be several years because of that statutory cap. Currently, USCIS is looking at applicants that were filed in May of 2016. And what could happen before a final decision is made on that application is that CIS can issue a request for evidence. And so if this does happen, we recommend you reach out to NIJC immediately because those have a deadline. It's important to also note that all immigration notices are only sent to the attorney of record. And so we do ask that you provide us a copy of anything filed, so that can be electronically, and also provide any notices to your client as well, because they will not receive anything. Okay, next. So I'm actually going to go a little bit more in depth about that U visa waitlist and deferred action here. When a U visa application is reviewed by USCIS, so right now, again, they're reviewing May of 2016. If USCIS deems the application approvable, but there is no U visa immediately available due to that annual cap, CIS will place the case on a wait list and grant the applicant deferred action. Deferred action is not a legal status, but it does offer protection against being placed in removal proceedings. At this stage, the principal and the derivative become eligible for that work permit based on deferred action, which is that C-14 category. Again, if the I-765 wasn't initially filed, then this is the time to file it once they're placed on that wait list. We ask that pro bono attorneys agree to stay with the case until the client has been granted the U visa. However, we do understand that the adjudication process is very lengthy, and so we do offer the option of transferring a case back to NIJC once it is placed on the wait list and granted deferred action. Okay, next. So because of these long adjudication times, it is very crucial to keep in touch with your client. I know some of you mentioned earlier in the polls that this was actually one of the most difficult things maybe you might come across when working on a U visa. It's easy to lose communication with your client. Therefore, we do recommend you check in with them every 6 months or so. This can be maybe setting up a calendar reminder or anything else that you think will help you. Clients should also notify you if they divorce, if they get married, if they get arrested, or if they're planning on moving. If the client moves to a new address, the law does require that CIS be notified. And so you will need to file a change of address with the Vermont Service Center. And you can see the special instructions on the USCIS website. And you should also notify NIJC of any change of address so that we're aware of it. And also, if we can go back a little bit, so also you as the attorney of record, if you change addresses, you must also notify NIJC and the Vermont Service Center. Remember that all notices arrive only to the attorney of record, which is why it's important to have your current address filed with the Vermont Service Center. Okay, next. And so you should receive approval notices of all forms once USCIS has reviewed everything, they made a final decision, there's a U visa available. Keep in mind that notices may arrive separately. Notify NIJC when you receive anything on the case. If a client has questions about traveling or if a derivative is outside of the US, you can refer those questions to us. Basically, after 3 years of having the U visa, clients could be eligible to get their green card or adjust status. So if a client contacts you about this, please refer them back to NIJC for a legal screening. It's important that they do apply for adjustment of status before their U visa expires, or they can lose their eligibility to do so. And they can also lose that eligibility if they travel outside of the US while they have U non-immigrant status. Okay, next slide. So here we include some legal references that we've used throughout this presentation in this PowerPoint, as well as referrals that you can use. Feel free, again, to use this PowerPoint as a reference tool for your future casework. And the next slide, some more resources here. And the next slide. Okay, so basically right now, we're at the end of our presentation. So what will happen after this is that we will send a follow-up email with the survey and all the resources. And so I hope that this training has been helpful. Here we have Trisha's and my contact information so that you can reach out to us if you're interested in taking on a case or if you have any questions. You should also be receiving NIJC's email newsletter. And also, please complete the survey. Trisha, if you can go to the QR code slide, I think it should be, there you go. We would be very grateful if you complete this survey to tell us how we did. I will also link this in the chat. It should take less than 5 minutes to fill out, and it's really helpful for us in order to keep up our pro bono programs up and running. And also for whoever is interested in Illinois or Indiana CLE credit, please make sure to fill out this survey and then send me your ARDC number via email if you did not get to enter it when you registered. And I think we have time for questions and then maybe case examples.
Yeah, I'm just checking to see if there's any questions here. I don't see any at the moment, but folks, feel free to type your questions into the chat. We've answered the ones that people had. So go ahead, Liz and Marissa.
Great. Okay, Marissa, do you want to take it off with the first case example?
Sure. Let me pull it up. Okay, so our first case example. Maria was born in El Salvador and entered the United States by crossing the border with a group of people she did not know through Mexico in 2010. The first time she tried to enter, she was stopped by immigration and returned to El Salvador. She entered successfully a few weeks later and had no contact with immigration. She met a man at work who was also undocumented, and they married in 2013. They had 2 US citizen children together. After Maria's daughter was born, her husband became jealous and began to drink heavily. In one incident, Maria's husband was intoxicated, and he began smashing their dishes in anger. He threw plates and cups at Maria, and she was injured. She called the police for help, gave them a report of the incident, and her husband was arrested. Maria got an order of protection against her husband and does not know if he was ever prosecuted for the incident. So we have a couple questions to go along with this scenario. The first one, has Maria been a victim of a qualifying crime? If so, which crime? And you can put your answers in the chat box. Give everyone a couple moments. Okay. I don't see any comments, so we'll go on to the next one. In this scenario, Maria was most likely a victim of domestic violence, although she also could have been a victim of felonious assault as well. Has Maria suffered substantial mental and physical harm? What are some examples of evidence that you could use?
Okay, so somebody said police report on the chat.
Yes, definitely. Police reports, any other comments? Yes,
Doctor's
report. You could use her affidavit as well, her account of what happened. That's often one of the best pieces of evidence in a case. Witness statements. Great. Okay. And has Maria cooperated with law enforcement? What did people think?
Yes, she called the police.
Yes, she made a report. Great, yes. And so based on the scenario, it seems like Maria did cooperate. She called the police, she made a report. It's also very important that Maria continues to cooperate throughout the investigation if requested by an officer or a detective. Does Maria have any potential derivatives? So in this case, yes, no, she does not. Her husband is the abuser, so he cannot be included on the petition, and her children are all US citizens. Does Maria require a waiver of inadmissibility? If so, what would be her inadmissibility grounds? Entry without inspection, definitely. Anything else? So in this scenario, it said that she entered once and was returned by immigration officials to her home country, and then she re-entered. So she could possibly have a prior removal from the United States. Yes, I see that someone just commented that. In this case, she did not smuggle anyone. Although she entered with a group of people, she did not actually bring people with her. Okay. And I believe that's it for the first scenario.
Thank you everyone for participating in that. I think we have maybe time for one more, Trisha, unless there's other questions.
No, go right ahead. I'm trying to answer them as they come in, but you guys are doing great answering all these questions. There was one question that other folks might have. What do you do to advise clients when they need assistance in other legal matters, such as a divorce or custody? So we can provide you referrals for all sorts of other legal matters, but your pro bono representation is limited to the U visa case in this scenario, right? So you will not be asked to provide legal advice or representation in any other matters. But we do try to provide clients with referrals for anything else that they might need.
Great, thank you. Okay, so on to case example number 2 for Jane. So Jane is a citizen of South Korea who entered the United States on a tourist visa in 2015. She told immigration that she was going to the United States on vacation, but she was planning to come work and did not intend to return. Jane came to the United States with her husband, who was abusive and violent in South Korea as well as in the United States. Jane's husband frequently locked her in their house and threatened her. In one incident, Jane's husband severely beat her and she was taken to the hospital by her neighbor. At the hospital, Jane spoke to police and made a police report. From the hospital, she went to a domestic violence shelter. Her husband was then taken to prison, and Jane testified in court several times, and he is currently serving out his sentence. So, for this scenario, has Jane been the victim of any qualifying crime? And if so, which crime? Yes, exactly. Domestic violence. Someone said possibly a felonious assault. So we would have to look at that police report, right, to see what crimes were investigated, what the description of that crime was. Someone else said maybe hostage. Possibly, maybe. Bawa, if her husband is a US citizen, that's a good point. Do we know he's a US citizen? We're not sure here, but that would be one of those questions that we would ask in the consultation. So good point. And has Jane suffered any substantial mental or physical harm? And what evidence could she use to support that? Okay, that's correct. Hospital records. She could definitely use that. Police report, definitely. Court records, hospital records. Yes. How about when she went to the domestic violence shelter? Do you think that maybe she can get a letter from there to support? Pictures of injuries, right? Exactly. Letters from friends, maybe as well, if they knew of the domestic violence or what happened. And possibly, maybe if she ever attended therapy, which might have been likely, but we just don't know this from this description. She attended a domestic violence shelter, maybe she received some counseling services there, so that might be helpful to obtain that if possible. And if not, then sometimes we might encourage clients to go to therapy if this is something that they would consider for themselves and also for their case. Okay, and has Jane cooperated with law enforcement? Yes, yes, she did. And she actually cooperated with the prosecution as well. She testified in court several times, and the abuser is serving out his sentence because of that. So she has a very strong case here. And do you think that Jane has any potential derivatives? It doesn't look like it. And again, her husband can't be a derivative, and we don't know if he's a US citizen or not. Right, he is an abuser, and so she can't include him in this petition. And presumably, there are no children here. So we don't know if she's what her age is, Jane, but if she did have children who were under 21, she could potentially include them as derivatives, but it doesn't look like she has children in this case. And lastly, does Jane require a waiver of inadmissibility? And if so, what do you think might be some of the grounds of inadmissibility that she would need waived? Yes, so someone said, does the material misrepresentation play a role in any inadmissibility? So yes, when Jane came to the United States, she told immigration that she was going right on vacation, but she planned to come to work and did not intend to return. So we might consider this something that we would try to put in her waiver of inadmissibility to be waived: fraud or willful misrepresentation. That's correct. Okay. Thank you everyone again for participating. You all did great. So Marissa, do you mind doing this next case example?
Sure. Okay, so case example 3. Robert is a Polish citizen who entered the United States with a tourist visa through O'Hare in 1990. He came with his son, who was 10 at the time and also had a tourist visa. In June of 2017, Robert was returning home from work late at night when he was stopped by 2 men. They threatened him and told Robert to give them his wallet and phone. When Robert refused, the men severely beat him, and one of them stabbed Robert in the leg with a knife. Someone called an ambulance, and Robert was taken to the hospital. Robert made a full police report and later went to the police station to follow up on the crime. However, the perpetrators were never found. The case is now closed. Robert did not seek therapy, but he continues to have nightmares and fears walking alone at night. So, what do people think? Was Robert a victim of a qualifying crime? If so, which crime? Yes, felonious assault. Has Robert suffered substantial mental or physical harm? And what evidence could you use to prove that? So someone said, yes, he could provide his own written affidavit on the nightmares. And yes, you could get the affidavit and maybe see a psychologist. Great. Anything else? It says that he went to the hospital, so he could definitely use those medical records from when he sought initial treatment, and if he is going to any ongoing medical appointments as well. He might consider seeing a therapist, in which case the therapist could write a letter of support for him. And has Robert cooperated with law enforcement? And what is the relevance of the fact that the perpetrators were never caught and prosecuted? Okay, someone said, yes, he helped with the investigation. It doesn't matter that the perpetrators were not caught. That's correct. Someone else said, absolutely has cooperated. The perpetrators do not have to be prosecuted for Robert to receive relief. That's absolutely correct. As we discussed previously, as long as the victim was helpful in the investigation, that is enough to qualify for the U visa. There does not have to be prosecution. And then it's also okay if the perpetrators flee and they're not found. Okay. And does Robert have any potential derivatives? So think about how old his son would be when the crime occurred. So his son was 10 years old in 1990. The crime occurred in 2017. So we have some people, so some people said that, yes, he could be a derivative, but actually he is now too old to be a derivative because he is 28 years old. Okay. And does Robert require an I-192 waiver? If so, what would be his inadmissibility grounds? Okay, so because Robert entered on a visa, he does not need a waiver for an entry without inspection. However, it is important that he did not commit fraud when obtaining his visa or entering the US by providing false information or misrepresenting his intentions of coming to the United States. Let's see. Other comments? Okay, so again, we would want to talk to the client in the consultation to get more information about how he obtained that visa and what exactly he said to immigration officials when entering the US. Thank you, everyone, for participating. Do we want to go on to our next case example?
Okay, so now this is the Sandra case example. Sandra is a citizen of Mexico, and she entered the United States using her US citizen aunt's identification in 2013. Her 8-year-old son entered the United States with this aunt 2 years later. Sandra and her son moved in with her partner, and after a while, her son began acting out and having problems at school. Sandra found out that her partner had been sexually abusing her son and immediately reported this to the police and to her son's school. Sandra's partner was prosecuted and is serving a jail sentence. Both Sandra and her son are now attending therapy regularly. And so, has Sandra been the victim of a qualifying crime here? So I don't see anything in the chat yet. Oh, something popped up. Yes, so what would be the crime? In this case, it would be sexual assault, right? It could be rape, abusive sexual contact. We'd have to take a look at that police report, that narrative, but I mean, based on this description, that's what it is. And so there are many possibilities here. Sandra could be an indirect victim, while her son could also be the direct victim here. So he was the one that was the direct victim of sexual assault, while Sandra was the indirect victim as the mother who also reported this to the authorities and reported it to the children's school, and she helped in the prosecution of the case. And so Sandra can be the principal applicant, while her son can be the derivative in an application. Also, her son can be a principal while Sandra a derivative because he's still, he was underage. He is underage. So they can both be principals essentially here. So we would have to see what would be the best plan here for them, what would be the most convenient for them in this scenario for them to apply. But the good thing is that they both can apply for the U visa in some way or another. Has Sandra suffered substantial mental or physical harm, and what evidence do you think that she could use if she were to apply as the principal applicant? Therapy records, that's correct. I mean, just because the mother didn't directly suffer the assault, she did suffer substantial harm because this was her son, this was her child who was the victim here. And so she suffered a lot of psychological harm. Maybe she might blame herself for what happened, and they're going to therapy, just like some of you have mentioned. A clinical assessment would be very helpful. Those therapy records, a letter from the counselor, records of the school calling her because of her son's actions. That's true, right? How has this impacted their life? So their life as a family, their life individually. So they can definitely use all of that. And has Sandra cooperated with law enforcement? Yes. Yes, she made the report to the police. And actually, we would ask more information to Sandra if she were to apply as a principal, whether she went to court, whether she was summoned, right, to testify. And if so, that would be helpful too for cooperation to add. So we don't know from the scenario whether she did, but I mean, there was a prosecution, so maybe. Yes, if her son had to testify, right, that's true. Does Sandra have any potential derivatives? Yes, as we mentioned, if she were to apply as a principal, her son can also apply as a derivative because he's under 21. And let's see. So we also don't know if Sandra is in a relationship with somebody else and they get married. So if they marry before the U visa application is filed, she can actually include the spouse as a derivative as well. So this sometimes happens in some of the cases that we have where initially they might not be married to the person that they're with. And in this scenario, it wouldn't be the person who committed the crime, obviously. But let's say a few years have passed, Sandra moved on and she is now with somebody else, they get married and she wants to file the U visa as a principal, she can include that spouse. And does Sandra require a waiver? of inadmissibility, and what would be some of those grounds? So one of the grounds, yes, somebody said stating that she's a US citizen to an immigration official. Yes, that would be a false claim to US citizenship. And possibly, we don't know this yet, and we would have to ask more details of this, but there could possibly have been smuggling as well of her child. So even though her child didn't come directly with her to the US, there could have been smuggling because maybe she paid for her son to come to the US without inspection, or she helped in any way or asked this family member to bring her son. So we would include smuggling there as well, just to be safe. And that concludes all our case examples. Again, thank you so much for everyone who participated. I know it was a very long training, but this is a lot of information because these applications do require a lot of time, a lot of attention. And so we're very thankful for all of you that stayed with us. And hopefully we did a great job, and you can fill out the survey for that. So thank you.
Yes, thank you all. So that takes us to exactly 1 o'clock. Thanks for sticking with us for these last 2 hours. Please fill out the survey and reach out to us as soon as you're ready to take on a U visa case. We're excited to work with you. Thank you all and have a great day.